Continuing our discussion of property, in this chapter we're going to cover how to dispose of property at death. So we're going to talk about wills, trusts, and advanced directives. Probate is the process of handling the will and the estate of a deceased person. And each state has its own laws passed by its legislature, and they're different from other states. They govern the writing of wills and the settling of estates. So for this reason, it's necessary to check your own state law to ascertain the rules for writing a will and to determine how property passes when someone dies. There is a uniform probate code, but only 16 states have adopted it. So the rules of wills and estates do differ from state to state. We're going to talk about just some general overarching principles in this chapter. But first, we're going to talk about some terms. So first, a will is a formal document that governs the transfer of property at death. A person who dies with a will is said to die testate. If you die without a will, you're said to die intestate. A person who makes a will is a testator if a man, a testatrix if a woman. Personal property left by a will is called a bequest or legacy, except in states that have adopted the Uniform Probate Code. Real property that is left by a will is known as a devise. And then the broader term referring to a person who inherits property under a will or from a person dying without a will is an heir. So again, a bequest is personal property left by a will. A devise is real property left by a will. And remember the difference between the two. Personal property is tangible. I can pick it up and move it. Real property is land, buildings, everything attached to it. Beneficiaries are those who receive property by a will. And then a durable power of attorney is a document authorizing another person to act on one's behalf with words stating that it's either to survive one's incapacity or become effective when one becomes debilitated. In order to validly execute a will, it must be in writing, signed by the testator, and attested to in the testator's presence by the number of witnesses established by state law. So there's one exception to the requirement of writing, but most wills must be in writing, signed, and then attested to means basically witnessed. Another, depending on your state, one or two witnesses who sign in the testator's presence. Each of these statutory requirements will vary based on where the will is made. A will may be typewritten or handwritten, or it may consist of a filled-in form. It doesn't have to be under seal. The will offered for probate must be the original and not a copy. In a case in which a testator executed both an original and a carbon copy of a will and later canceled only the carbon copy, the court has held that it could be presumed that the testator also intended to cancel the original. Problems like this can be avoided by executing only an original will. So oftentimes people will execute multiple original wills. A will must be signed by the testator. The place of the signature on the will and the requirement as to who must be present at the signing vary from state to state. It is important that we accurately choose our words when we're executing a will, when we're drafting and executing a will, and that's why it is important to obtain the counsel of an attorney or another experienced preparer of wills, because certain words often used in wills may have a legal meaning different from their everyday meaning. So oftentimes people use the word heirs in their will if they draft them themselves and they want it to mean children, but that's not what heirs mean. Heirs for legal will terminology just mean people inheriting. So it can get confusing. There are some allowable versions of informal wills. There's the holographic will, which is one that's not witnessed, but it's written entirely in the handwriting of the testator. So this one is allowed. It's an admissible will, even if it's not witnessed by others, if it's solely in the handwriting of the testator. And then there's nuncupative wills, which are oral wills made by persons in their last illness or by soldiers and sailors in actual combat. This is the only time that the will doesn't have to be written, and it's somebody basically on their deathbed or soldiers and sailors in actual combat. There are some provisions to protect spouses if the spouse was either left out of the will or if they didn't receive very much in the will. The first is the widow's allowance, which is an amount of money taken from the decedent's estate and given to the family to meet its immediate needs while the estate is being probated. There's the homestead exemption, which puts the family home beyond the reach of creditors up to a certain limit. So after one dies, the creditors of the deceased can't come back and take the home if there is a family still living in the home. There's also exempt property, which is certain property of a decedent that passes to the surviving spouse or children and is beyond the reach of creditors. Most state laws contain various devices that are designed to give protection to surviving family members when a spouse dies, and the amount of the allowance is either a fixed statutory amount or a discretionary amount with the court, and is not chargeable against other benefits given to the family members. In some states, for example, $3,500 worth of personal property passes automatically to the surviving spouse, or if none, to the surviving children equally. The rights of dower for a widow or curtsy for a widower are also available in some states, providing the surviving spouse with certain property rights and real property owned by the deceased spouse. There's also what's called a forced share, which is an amount that the surviving spouse who doesn't like whatever they receive from the deceased spouse will, they can choose to take a portion of the estate set by statute rather than accept the amount provided in the will. And this is an elective provision. And this, of course, varies from state to state. There are also protections of children in some states, but this only applies to children who can prove they were mistakenly rather than intentionally left out of a parent's will. So if these are called forgotten children, and forgotten children usually receive the same share they would have received had their parent died without a will. So state law would prescribe what would go to the children if there was no will at all. And so if a child can prove they were mistakenly left out of a will, they will get that part of the estate. And so this might be easily proven if parents maybe had 2 kids and they wrote a will and then they had the 3rd child and they never updated their will. So that it would be pretty clear that that's a mistake. But if a parent had 3 children and then wrote their will 3 years after having their 3rd child and didn't provide for their child in the will, that looks more intentional. A will can be revoked, so I can draft a will and then I can revoke it. And I can revoke it in a clear and convincing way, one of these 3 ways. I can burn, tear, cancel, or obliterate the will with the intent to revoke it. I can execute a new will, or in some states, the subsequent marriage of the testator would revoke the will. So if I get married again. And in most states, the divorce or annulment of a marriage revokes all gifts made under a will to the former spouse and revokes the appointment of the former spouse as the executor of the will. I can also change a will by executing a codicil, which is a formal document used to supplement or exchange an existing will. If I want to do this, then the codicil must be executed with the same formalities as a will. So it must be signed by the testator and properly witnessed. In addition, it must refer to the existing will to which it applies. A will can also be contested, and it can be contested on one of 3 grounds: improper execution, unsound mind, and undue influence. Improper execution occurs when an individual has attempted to make a will but has not followed the formal requirements. Because lay people are not usually aware of the formal requirements for executing a will, it can be risky for them to make their own. Another grounds to contest a will is to allege that the testator was of unsound mind. When such an allegation is made, the burden to prove that is on the person presenting the will to the court to prove the testator was of sound mind. This proof may occur by testimony and affidavits of witnesses and by testimony of the deceased physician. A will may also be attacked and held invalid if a probate court finds the testator made the will under circumstances of undue influence. When persons come under undue influence of another to the degree that they are unable to express their real intentions in a will, the will may be declared invalid. So we see undue influence a lot when we have an elderly person and maybe their caretaker, and then all of a sudden the elderly person leaves everything to the caretaker and nothing to their family. Only persons who would inherit under an earlier made will or under the law of intestacy are allowed to contest a will. Intestate succession is the state law that contains the rules governing the allocation of intestate property. So these vary from state to state, and these are the laws that prescribe what would happen to your property if you died without a will. And this is just an example. They vary really greatly from state to state, and of course they depend on what types of heirs you have, right? If you have a spouse, if you don't have a spouse, if you have children, if you don't have children, there's quite a bit of variation. The Uniform Simultaneous Death Act contains rules that are followed when the inheritance of property depends on the time of death, and there's nothing to indicate that the parties died other than at the same time. So maybe a husband and wife died in a car crash, and we don't know how to distribute property. We would do that using the Uniform Simultaneous Death Act. The following rules are followed. The separately owned property of each person passes as if he or she had survived unless a will or trust provides otherwise. For example, if a husband and wife die together in a crash, the husband's individually owned property passes to his heirs as though his wife were not living at the time of his death. Similarly, the wife's individually owned property passes to her heirs as though her husband were not living at the time of her death. Property owned jointly by both of the deceased is distributed equally. If, in the husband and wife example, half the couple's jointly owned property passes to the husband's heirs and the other half passes to the wife's heirs. When the beneficiary of an insurance policy dies at the same time as the deceased, the proceeds of the insurance policy are payable as if the insured had survived the beneficiary. So that in the husband-wife example, say that the wife had a policy on her husband's life and she was the beneficiary and they died at the same time. So there, we would pretend like the husband died before the wife. All right, when we're settling an estate, it goes through probate. So when people die owning assets, their estates must be probated. And that is a settlement under the supervision of court. Before an executor or administrator is appointed, notice of the petition for appointment is published in a newspaper and sent to all heirs, legatees, and devisees, and anyone with grounds to object may do so at that time. So first we need to decide if the deceased left a will, and if there is a will, it usually names someone, a personal representative, called the executor or executrix, if female, to carry out the terms of the will. If there's no will, or if the executor named in the will fails to perform, someone must petition the court to settle the estate. Advance directives are written statements in which people give instructions for their future medical care if they become unable to do so. These are living wills and health care proxies. A living will is a written expression of a person's wishes to be allowed to die a natural death and not be kept alive by artificial or heroic methods. Another vehicle used for this is the healthcare proxy, which is a written statement authorizing someone else, an agent, to make medical treatment decisions for another in the event of incapacity. One way that property can pass outside the operation of a will is by setting up a trust. And a trust is a legal device by which property is held by one person who is the trustee for the benefit of another, who's the beneficiary. When a trust is established, the title to the property is split between the trustee and the beneficiary. The separation allows the trustee to manage the property for the benefit of the beneficiary. Trusts are established for many reasons, maybe to save taxes, to provide for the needs of young children, and prevent money from being squandered, among other reasons. So a trust is often a three-party device. So say I want to set up a trust and I contribute my funds in trust for the benefit of my children. So in that case, I transfer my money in trust and someone manages that, and that is the trustee. The trustee can be me, but it's often someone else to save on taxes. and they manage it for the benefit of my children, the beneficiaries. There are two broad categories of trust and lots of different smaller categories underneath these, but the testamentary trust is a trust that's created by a will, and it doesn't come into existence until the death of the testator, so it is created by the will. Then there's a living trust, which is an inter vivos trust, and it comes into existence while the settlor is still alive, and it's established by either a conveyance in trust or a declaration of trust. A conveyance in trust means that the settlor conveys away the legal title to a trustee to hold for the benefit of either the settlor or for another as a beneficiary. And the declaration of trust is when the settlor holds the legal title to the property as trustee for the benefit of some other person to whom the settlor now conveys equitable title.